Good morning, everyone. So, as you heard, our last session this morning is going to look at social media in the workplace. It goes without saying that social media usage has grown substantially both in people's personal and in their professional lives. Now, for employers, social media has become a valuable resource for the business itself, but it can also be quite a hindrance, as some of you in this room probably know, particularly from an employee relations perspective. So in today's session, we're going to look at what social media means for businesses, first discussing some of the benefits and risks of using social media, before going on to consider some key concerns for employers, so key concerns that we particularly hear as a practice. We'll then move on to look at some practical tips for businesses, and finally briefly look at points to bear in mind when and if employers are monitoring employees' use of social media. So on this first slide, we've got some figures showing the number of active monthly users or number of users of social media, albeit on a global basis. But if we take the top one, if we take first Facebook as an example with 1.65 billion monthly active users, it clearly shows its popularity. Now, there are also newer forms of social media. So if we look at the fourth one on the slide, Instagram, that has a currently growing membership with currently 600 million active monthly users. So again, what this demonstrates is the prevalence of social media membership, both personally and professionally. Now, applying this to business, there are undoubtedly benefits of businesses using social media, and I'm sure some of you in this room use social media in a positive way as well. So you can maintain contacts, such as with current colleagues, former colleagues who've moved on to pastures new, customers. So it can be quite an important and useful networking tool. Equally, social media can give an employer a platform to post or gain positive publicity about a particular product or a new campaign, can give you new work, or equally it can maintain a strong brand name within the marketplace. Now, even though such benefits exist, there can also be risks for employers in using social media themselves or in their employees using social media. And employers are increasingly concerned about issues arising from social media usage. So what are those risks and what are those concerns? We particularly hear the following three forms of concern. The first is all around new forms of social media and keeping up to date with the constantly evolving social media landscape, trying to understand how they work and what consequences that form of social media could have for a business can be quite tricky. The second is all around recruitment and specifically social media vetting as part of the recruitment process. So as David was saying, it is increasingly common for employers to review applicants' social media profiles as part of the recruitment process. But are there risks in doing that? And we'll come on to look at that and answer that a little bit later. But the most common form that we hear, and no doubt keeps a lot of you in this room busy, is around inappropriate use of social media by employees. So just using social media in the office rather than employees getting on with their work could become a performance issue for time wasting. Then there's also employees posting about work, customers, colleagues on social media and social networking sites. And those comments and posts that they're making are either unprofessional or they could be damaging to the business's reputation. I think it's fair to say, in terms of what we find anyway, there is an ever-growing line of case law and cases being brought in the employment tribunals around social media. So it's important to be aware of the pitfalls, and we'll come on to look at some of those in a moment. But before we do, one thing to note is that employers can be held responsible for the actions of employees carried out in the course of employment. Now, in the course of employment is construed quite widely, so it's likely to cover actions outside of as well as inside of the workplace, depending on the facts. The recent Carphone Warehouse case is an example of where an employer was found liable for an employee's actions through their use of social media. So in this case, two employees took their manager's iPhone without his permission, went onto his Facebook account and posted on his Facebook page I'm finally out of the closet, I'm gay and proud. Now, the manager wasn't gay, and there was no reason for the employees to suspect that he was, but the manager was deeply offended by the comments that were made, so much so that he pursued a sexual orientation harassment claim in the employment tribunal. And the employment tribunal found that Carphone Warehouse was in fact vicariously liable for the actions of those two employees and was penalised quite heavily in order to pay a particularly heavy fine. Now that was because, and this is quite a clear-cut one, but the actions of the employees were in the course of employment. They were in normal working hours. So it's worth bearing that one in mind. There is a possible defence available to employers under the Equality Act if they can show that they've taken steps to prevent the employee from carrying out the unlawful act. So having employment policies in place setting out what behaviour is acceptable and unacceptable in this case at work is going to be helpful. So the sorts of policies that we're thinking of there will be a social media policy or, particularly relevant in this case, an anti-discrimination policy. So looking at the awareness of social media concern in a bit more detail, a common scenario we come across is when a potential disciplinary matter arises concerning a member of staff's use of social media and the challenge of trying to work out and understand how that particular form of social media works. This isn't generally going to be the case for Facebook or LinkedIn. It could, of course, be. But with the increased use of individuals of other forms of social media and new forms of social media cropping up all the time. So one example that I've heard quite a lot about within the last few months from various clients has been Snapchat, which some of you in the room may or may not have heard of. But the important thing there being that if you are notified of a possible disciplinary matter and you haven't heard of that form of social media or you don't understand what it is, which, you know, for the record, is perfectly understandable, you know, there can be a difficulty in understanding what to do from then onwards. So with that in mind, it's really important to spend time understanding how the particular form of social media works. So this will be important at the investigation stage. So in particular to understand whether there is a case to answer and whether there's a case to invite the employee to a disciplinary meeting. It's also going to be important from the decision maker's perspective, and that's both at the investigation stage, as I've just mentioned, but also at the disciplinary meeting itself, to understand whether a sanction should be awarded, and if a sanction should be awarded, what is that sanction? How serious is the matter that's you know, taken place, and also whether damage has been or could have been caused, rather than having any knee-jerk reactions. So an important one to bear in mind, I think. Moving on to recruitment. Now, this is looking specifically at social media vetting, and some of you in this room may already do that as part of your recruitment process. I think it's fair to say that, in our view, if you are doing that, then it comes with a health warning. It could be justified where there are particular circumstances or significant risk to the organisation by recruiting for a particular position. But otherwise, employers should be careful about doing so. At best, social media screening is generally only going to be, or it's only going to give you limited grounds for legitimately refusing to progress a candidate's application anyway. So it's worth thinking about how helpful it actually is in the first place. So you might do it as a matter of course, but do you actually need to do it? What information are you going to glean from it? The main point here, though, which David mentioned, is all around discrimination. So screening applicants' social media profiles may give unfair advantage or disadvantage to certain individuals or certain groups of individuals. As David said as well, you know, job applicants are covered by discrimination legislation, so it would be open to a job applicant to say, you know, you didn't choose me for that particular role, you didn't invite me for interview because of my sex, race, religious beliefs, etc. Now, in practice, it is probably going to be difficult for a complainant to prove that social media screening alone influence the employer's decision to not invite them for an interview or not give them a job. But it is possible, and it's for that reason that we mention it, and why organisations should carefully consider their approach to social media screening. The Information Commissioner and ACAS have both published guidance on vetting candidates as part of the recruitment process, and that guidance is relevant to social media screening in particular. So key points, some key points arising from the guidance on the slide. So if you are going to monitor social media as part of the recruitment process, inform applicants that that's going to take place. As much as anything, it might encourage the applicants to clean up their social media file or profile or change their privacy settings. So from a recruitment perspective, it might not be that helpful, but the point is to at least tell people that you're going to do it if you actually are. Make sure that you have clear procedures in place and apply them consistently. So make sure that if you are going to vet people's social media profiles, you're doing exactly the same thing with everybody. You're not sort of marginalising a particular group of individuals or an individual himself or herself. Consider carefully which sites and searches are appropriate and whether they are fair and proportionate to the role, taking into account the required skills. That's particularly important. But the one particular point to think about is going to be when you undertake the search, and the Information Commissioner and ACAS would recommend that it should be done as late in the process as possible. So, for example, only at the point that an offer has been made, or before that potentially when they've been shortlisted for interview. If you do it sort of any earlier then things could get a bit problematic. And finally, make sure that if you undertake equality and diversity monitoring as part of your recruitment process, that you keep that information entirely separate from the application form, the CV, cover letter, etc. If they are together, then it could assist an applicant in showing that a discriminatory practice was used by the organisation in deciding who to shortlist or ultimately who to recruit. So if we turn now to look at inappropriate use of social media, as we know, it may become necessary to take disciplinary action against certain individuals, and in some cases dismiss employees for their actions as well. Let's look at a few examples of cases where a fair dismissal has been found by the tribunal. So firstly, in the Gill case, posting about performing other work whilst on sick leave was held to be a fair dismissal. So in that case, the employee had a keen interest in modelling, and that didn't form part of her role, but she attended London Fashion Week, and whilst she was there, she said that she'd been there for 5 days, this is on her Facebook page, and had auditioned 300 models for a particular show that she was carrying out. Now, if we park the bit about whether she was doing something she should have been anyway, to the extent that was she allowed to do that given the role that she had, the key point here though was that she did all this while she was off on sick leave. So understandably the Employment Tribunal found that it was a fair dismissal in that case. In the Crisp and Apple case, Apple dismissed an employee for criticising Apple's products on social media. This is quite an interesting one because Apple had a social media policy in place that specifically said that employees of Apple were not allowed to comment on social media about what their thoughts were on Apple products, whether they were new or old. And the reason why they, or how they justified that, was that they said that it was aiming to protect the ultimate image of Apple. The keywords used by Apple were the core value of the business, the core values of the business. And again, the Employment Tribunal found that the employee's dismissal in that case was fair. Dismissing employees after it comes to light that employees posted derogatory comments about their employer a number of years previously has been held to be a fair dismissal. In the 2 cases mentioned, the latter was a couple of weeks ago. So that there was a delay in the employer taking action didn't matter. And finally, referring to the workplace as Dante's Inferno, which I'm sure we'll all agree is quite a striking image. when an employee's social media policy included a requirement not to badmouth the workplace, was found to constitute gross misconduct by an employment tribunal. So it's, as I say, there are 4 examples there. They are just examples, and it's really important to bear in mind that an employment tribunal will look at all of the facts in the case. So these examples, as I say, demonstrate circumstances where a fair dismissal has been found, but an employment tribunal will want to take more information into account. But let's look at the other side of the coin. So unfair dismissals. What circumstances have been found to constitute an unfair dismissal? So where there is no evidence of reputational damage, so in the Witham case, an employee was dismissed for stating, "I think I work in a nursery, and I do not mean working with plants." So that was found to be an unfair dismissal because the employee's comments were relatively minor. And just in case anybody was interested, the individual didn't work in a nursery at all, as I'm sure you've probably gathered from the quote. But it's really important to look at what actually the employee has done and what they have said. In the Halford's case, an employee posted a comment on Facebook which said, "Halford's workers against working 3 out of 4 weekends." This was after a restructure. The disgruntled employee that posted that comment later found out, a couple of days later, found out that by posting that comment, he was in breach of Halford's social media policy. So as soon as he worked this out, he withdrew the post immediately. But unfortunately for him, Halford's had already seen it, and they decided to dismiss him. But the employment tribunal said that because he'd withdrawn the post, it was an unfair dismissal. In the Blue case, an employer's social media policy did not cover conduct outside of the workplace. So where an employee posted derogatory comments on Facebook about his employer outside of work and the employer dismissed him, the employment tribunal found that that dismissal was unfair, which you may or may not agree with. You might have your own views on that one. And finally, the Asda case here. So this was all about an Asda employee who posted, again, a comment on Facebook about hitting Asda customers on the back of the head with a pickaxe. Her manager dismissed, this employee's manager dismissed her for gross misconduct for posting that comment. But the employment tribunal said, it's quite serious and we'll support a finding of misconduct, but we don't agree with the fact that you dismissed the employee for that. So again, that was found to be an unfair dismissal. So again, 4 examples of unfair dismissals there, but bear in mind the facts of the case. It won't always be the case that a similar finding will be made, but they are quite 4 important pieces of guidance to bear in mind. So what practical tips can we bear in mind in social media cases and when you encounter these within your workplaces? The first is to ensure that the business has a social media policy in place. The case law consistently shows that having a policy, a social media policy, and one that's well drafted, is going to be invaluable in disciplining and ultimately dismissing employees for social media breaches. Be clear in that policy about whether employees are allowed to use social media in the workplace, and if they are, how much time are they allowed to spend doing that, and what forms of social media does that extend to. Set out what is and what is not acceptable. So one thing in particular which is helpful is being clear that offensive or discriminatory comments on any social media network may result in disciplinary action, and query whether that also extends to covering dismissal as well. Make sure that the social media policy covers social media outside of the workplace. We saw that that was an important point in the Blue case a few moments ago, but definitely make sure that it's clear that it does cover conduct inside and outside of the workplace. Be clear about what types of behaviour as well will amount to misconduct and gross misconduct, and use that as a guide in disciplinary situations. But be clear that those examples are not exhaustive. There will be other situations that could warrant a finding of misconduct or gross misconduct. Now, some of you may be sat there thinking, well, and the business I work for already has a social media policy in place and it's very well drafted and it includes all these things. And I think that if that is the case, well done. The next big thing, though, is making sure that your employees are aware of that policy. Showing that employees are aware of a social media policy can be very useful in persuading an employment tribunal that your decision to dismiss was fair, because ultimately they should have known that that conduct was not acceptable because of the contents of the social media policy. So you might want to consider whether you want to give your employees training on what the social media policy includes. Another idea could be to get your employees to acknowledge that they've read and understood the terms of the social media policy, so that you have something to rely on if things go wrong later on in the day. You'll also need to make sure that you deal with breaches of social media policies fairly and consistently with how you deal with breaches of any other policy. So this goes to the knee-jerk reaction point. Take that time to work out, if you're not sure, what that form of social media actually is and what it means and what the consequences are for the organisation, and then apply a policy of consistency across the board from there. So some other additional points that employment tribunals will consider when deciding on whether or not a dismissal is unfair. They will consider whether the employer has a social media policy in place. You've already looked at what that might look like and the sorts of things that we would recommend that would include. They will also look at the nature and seriousness of the incident. So, what's actually happened? What does the posting look like? Was the posting sufficiently serious? Was there any damage to the business? Those are the sorts of questions that they will be asking, and they will expect an employer to have thought about prior to awarding a disciplinary sanction to an individual or dismissing someone. We've seen in one of the cases that I mentioned this morning that mild comments won't be entertained by the employment tribunal, so they do need to be sufficiently serious. Think about the damage to the business and the business's reputation. Case law has shown that there needs to be real risk of potential damage or actual damage having occurred. So it is a particular bar, and it's one to be aware of. They'll also consider the circumstances and context in which the posting took place, in particular the situation in which the post was made, and ultimately who saw it as well. So if we think about Facebook and LinkedIn for a moment, if an employee has a significant number of friends or followers who are colleagues or customers of the business, then it could be the case that could be particularly detrimental to the business, obviously. So, by showing those sorts of facts to an employment tribunal, and hopefully, you don't have to, but in the disciplinary process itself, will be particularly helpful. And finally, look at the employee's record of conduct and whether they have any previous conduct warnings against them. An exemplary record of behaviour has been shown to have weighed heavily on an employment tribunal's mind in determining whether or not a dismissal is fair or unfair. And finally, and just very briefly, we wanted to look at monitoring your current employees' use of social media during employment, and just look at a couple of practical tips that you might want to think about. The first point to note is that covert monitoring of employees' use of social media is not generally going to be permissible. It will be, though, if there are exceptional circumstances whereby there are grounds for suspecting criminal activity or some sort of equivalent malpractice. So it's fair to say that is a particularly high bar. Monitoring use generally is permissible, though, provided that employees are aware of what is being monitored. So in such circumstances, it can be helpful to include a right to monitor in the employment contract or in an employment policy. I suppose in this case, a social media policy can be particularly helpful because it shows that you have a right to do that. There's obviously a point about whether in the policy that's a contractual right or not, but I think that having it as guidance in any event is quite helpful because, again, it gives you something to point to. That said, it's good practice for employers only to be monitoring employee usage of social media where it's necessary to prevent defamatory acts, and also where you're doing so for a specific purpose. It's also worth taking into account the monitoring itself, the extent of the monitoring, and whether it's proportionate to the potential harm of the activity that it's intended to prevent. But to touch on something I said, first of all about monitoring use of social media, it's important that if you are going to do it, good practice is to do so in a transparent way. So be open with your workforce that you're doing it and what it is that you're actually looking at and why you're doing that. And should you ever have to justify to an employment tribunal why you're doing that, those are the sorts of arguments that ultimately they will be interested in. And so with that, I'll hand back to Mark for questions.